It's an issue that's drawing the attention of women and families across the country. Today, the United States Supreme Court heard arguments in the case of Young versus UPS, in which a Virginia woman, Peggy Young, claims she was discriminated against because she was pregnant. Young was working as a delivery driver in 2006 when she became pregnant. After submitting a doctor's note advising she avoid lifting anything over 20 pounds, Young got an unexpected response from a UPS official.
She basically said, well, we don't give alternative work or light duty to off work incidents. I'm like, I'm pregnant. There's not an incident here and I could do my regular job, but they would not allow me to.
Young lost her job and her health insurance, so she sued for back pay and damages, citing the Federal Pregnancy Discrimination Act of 1978. So, is the law in Young's favor, and how could the High Court's ruling impact other businesses? Joining me now is Peter Moser. He's a founding partner of the Boston-based labor and employment firm Hirsch Roberts Weinstein. Welcome back to Greater Boston.
Thank you for having me.
So I guess everybody kind of assumes this was resolved back in 1978 with the pregnancy discrimination law. Why are we hearing this now?
Yeah, 1978 was the date of the enactment of the Pregnancy Discrimination Act, and it essentially established thou shalt not discriminate against women on the basis of pregnancy or pregnancy-related conditions. I suppose what's not resolved is what does it mean to discriminate? Certainly you can't fire somebody or punish somebody for being pregnant, but to phrase it the other way is, well, what if somebody can't do their job because of pregnancy? What is my obligation as an employer to accommodate that person? The employer might say, I'm not discriminating against someone on the basis of pregnancy. I'm treating that person the same way I'm treating everybody else, all non-pregnant employees who are similarly situated. If you can't do the job, the question is, to what extent do I have to accommodate?
But of course, they're claiming that she's not being treated like everybody else.
Right.
That other people, in circumstances like if they lost their driver's license, even for a DUI or something like that, or if they threw a back out and they couldn't list, they were given light duty. Why wouldn't they have done the same with her?
And this is why these cases get to go to the Supreme Court, because reasonable minds can disagree as to, you don't get this far up if it's an easy case. And the two ways of looking at it are this. I guess the answer hinges on who is the comparator. Right? Ms. Young would say, just as you said, look, you should compare me to the folks who you do accommodate. You've got a policy, UPS, that accommodates folks who have an ADA disability. You accommodate folks who've lost their DOT license temporarily, and you accommodate folks who are injured on the job. If you don't give me the same type of accommodation, you're not treating me the same. You're treating me different because of my pregnancy. That's one way to look at it. The other way to look at it, says UPS, is no. Your comparators are all the non-pregnant folks who are similarly situated to you. Those three categories we just talked about are the outliers, are the exclusions. Our policy covers them specially. Your comparators are all the non-pregnant employees, pregnant or non-pregnant. We treat everybody the same, says UPS, who have been injured in any other way than those three ways.
Well, two lower courts have thrown this out, have basically said she doesn't, it doesn't hold up. The suit does not hold up. But I mean, one of the things that the employer said to her was, well, we don't cover outside incidents, which is pretty funny, calling pregnancy an outside incident as if it were like falling and hitting your head while ice skating. So you brought that on yourself. So we're not going to be responsible. Is that part of the angle that the Supreme Court is? I mean, what angle are they looking at that hasn't already been researched?
Well, I mean, as you know, I'm a management side labor and employment lawyer, so I take the facts that one side alleges with a grain of salt. And the facts in this case have not been determined. There was never a trial in this case. The case was dismissed at the summary judgment stage by the lower court. So there's a dispute over some of these facts. I don't know whose version of the facts is correct or isn't. But I think the heart of it is what I was saying earlier. It's very much a legal issue, which is why it was able to be dismissed by the lower court, because it really doesn't hinge on the facts so much. The question is, really, who's her comparator? If you look at it Ms. Young's way, she's being treated differently because of her pregnancy. If you look at it the company's way, no, she's not. She's being treated the same as everybody else, who pregnant or non-pregnant, who's not affected in any one of those specific three ways that falls under the policy.
By the way, in terms of how the Supreme Court rules, they decided to hear it, but that doesn't necessarily mean they'll rule on it. Is that correct?
Oh, no, they'll rule on it.
They will.
Yeah, and I guess we'll get a ruling before June 30th of next year.
Usually
That's the end of the term, so we'll certainly hear the result by then.
So the people who testified to the Supreme Court, they each got like 20 minutes, but I'm sure the dockets are...
Right, I can only imagine, right?
All right. Peter Moser, thanks so much. We'll be standing by on that one.
Thank you.
Appreciate you coming.